at the Riverdale office in Toronto. And just a heads up, this webinar is being recorded. You can see the note at the top of the screen. The recording and transcription have started. We ask that people, if they have questions, type them in the chat, and then we will address them. Another sort of bit of housekeeping is we don't have a land acknowledgement today because we forgot to ask somebody to do it. And as an Indigenous person, I don't feel comfortable doing it. Just please be mindful of the fact that settlers are living on stolen land. And it would be a great idea if people did some research on the treaties in the areas where they live and knew more about the history of the land being stolen. Thank you. I just wanted to start off with a couple of stats before I turn it over to Faisal. The Black population in Canada is around 3.5%, but the Black jail population in Ontario specifically is around 13%. So you see the disproportion there. In Ontario, 1 out of 15 Black men have been in jail, but only 1 out of 70 white men have been in jail. In Ontario, Black women are 2.7% higher population rate of incarceration than white women. So it gives you a little bit of context. Many of you are probably already aware of this, which is why you're on this webinar today. But I'm going to turn it over to Faisal now to talk about the Sentencing and Parole Project. He's an experienced criminal trial and appeal lawyer, and he's argued numerous cases at the Supreme Court of Canada dealing with the Charter, sentencing, and human rights. He frequently appears at the Ontario Court of Appeal. He works often on test case litigation. He contributes to several legal organizations to develop initiatives to advance diversity and substantive equality. He is a graduate of the Osgoode Hall Law School, where he's an adjunct professor teaching criminal law. Over to you. Thank you.
Thank you, Katie, for the kind words and warm introduction. Good afternoon, everybody. It's a real privilege to be with all of you, to have an opportunity to share ideas, talk about the Sentencing and Parole Project, and have a conversation about important issues around anti-Black racism. I am a criminal lawyer. I've been practicing for about 20 years. Over the course of my career, I have observed something that I thought was an acute problem in the justice system, but was not sufficiently dealt with. And that is that Black people are overrepresented in the courts throughout the province of Ontario. They are over-incarcerated, as Katie indicated, by statistical measures. By other measures, they are mistreated while they are in prisons because of systemic racism. However, those experiences have not been visible to Crown attorneys, to judges, because of the way that the system operated. This type of information was not being consistently put before the court. That's not to suggest that specific segments of the justice system bear a direct responsibility. It does take time to develop a critical mass of people who have the expertise that are able to provide academic insight, provide clinical insight, and enable lawyers and people who are in positions of authority like judges to have access to this information. But that, at the same time, is not an excuse for the failure of the system for decades and generations to not make a more concerted effort to seek out this information, even at a basic and fundamental level, so that sentencing was more fair, that it was better informed, that probation conditions were better informed, and that parole was better informed in terms of assessing risk and assessing the conditions of release. You know, when I think about why that problem has existed for so long, I reflected on my own education from childhood through to law school and then into the profession. And what is clear is that the history and current context of anti-Black racism, especially for my generation, was not taught in high school. It was an obscure topic in terms of its availability in university. It was not taught in law schools. Now, pause and think about that for a moment when you think about how severe the overrepresentation problem is, and all you have to do is walk into a courthouse, for instance, in the Greater Toronto area, and it will be clearly visible to you, particularly in places like Brampton, in Toronto West, Finch Court, Scarborough, downtown, City Hall. But it's not limited to there. If you go outside of those core areas, you will also see an overrepresentation of Black people and racialized people overall. And so the fact that this is not taught within the institutional framework means that people that practice in the profession and then ultimately become judges are not well equipped to deal with an accurate assessment of the individual's background and circumstances. So what they have done is that they have asked counsel to essentially fill that gap by providing information to the court. And often counsel were not in a position to do that, or they have ordered pre-sentence reports, conventional pre-sentence reports that were authored by probation officers. Now, in an ideal world, a pre-sentence report would make perfect sense when there's going to be probation, so that the probation officer can interview the individual, provide a report, and indicate in a transparent manner the types of conditions that would be appropriate to foster the rehabilitation of the individual while also addressing any concerns the court may have with respect to accountability. However, the pre-sentence report often gets ordered in cases where there's not going to be probation conditions and that someone is going to be sentenced to the penitentiary and then go through the parole system. And so it somehow became a touchstone for everything for judges in terms of giving them the assurance, well, I have an understanding of this individual because I have this 3 or 4 page pre-sentence report that encapsulates their life in terms of their education, their employment, the community that they live in, and their family dynamics. The problem with that is that we know that the justice system has not just a racialized overrepresentation problem, but a very stark problem with respect to the intersectional issues of poverty, mental health, addiction, and only recently a recognition of racism. And when I say intersectional, I say that because these topics are not to be viewed as isolated categories or compartments. They actually do have a nexus to one another. And over the course of my personal life and career, I have observed that justice system participants do not really understand the trauma of racism. It should not be that the only time that mental health becomes relevant is if the individual is so severely ill that there's an issue as to whether or not they're able to actually understand their actions. The reality is that mental health is far more nuanced than that, and it has a broader impact on people's daily lives in a way that it really affects their trajectory in terms of how they respond in the institutions of education, how they deal with stresses in their neighborhood and communities, how they deal with employment circumstances. Many of us are very grateful that we live in Canada and that we have, a relatively peaceful society. We have a government that tries to be responsive to the needs of the community, that we have somewhat of a social safety system that allows us to live productive lives, and we have health care. But when you do a deeper dive in terms of what's going on with people that are before the justice system, you see the forces of exclusion and how powerful they are in their lives. And those forces of exclusion, for people who have been streamed in schools, who have been mistreated in the child welfare system, that have had difficulty accessing employment, that experience unique challenges in their neighborhood, are not on an equal footing with people that can walk down the street, with their dog in the evenings, not being concerned about being asked, where are you going? Why are you here? And other invasive questions about their identity under the rubric of, advancing public safety through policing. So these are difficult conversations that the court simply was not having. And you know, with full credit to the work of the people in Nova Scotia, in particular Robert Wright and Lana McLean, I think they were inspired by the Gladue context, but you know, I don't purport to speak on their behalf. I think they were also inspired by the fact that this gap in the system was resulting in not just an over-incarceration problem, but you were having people getting longer sentences than they truly deserve. And I can tell you as a defense lawyer that when I represent people of means, particularly professionals, and if they're found to have committed an offense, they're not going to get a pre-sentence report authored by a probation officer. They're going to use their resources to get private materials that are going to provide extensive reviews of their personal history, their mental health, their family dynamics, the reasons that they may have experienced trauma and why they essentially made a mistake in life. And what that means is they're viewed through a much different lens by the courts. They're not stereotyped. You know, they're not considered to be just another person from X neighborhood that has committed an offense and that therefore is deserving of being separated for an extended period from society. The conversation in the courtroom is fundamentally different because of the access to the information that the court has in that context. So based on the work of these pioneers in Nova Scotia, who I had the privilege of working with Emily Lamb, who was one of the co-founders of the Sentencing and Parole Project, we litigated a case here in front of Justice Nakatsuru in Ontario, where we were able to, for the first time, put this type of information before the court. And it was a unique case because the client in that situation was originally from Nova Scotia. Had spent most of his life there. So Robert Wright was the perfect person to come and interview him and write this very nuanced pre-sentence report. But it's interesting sometimes when you go through a case like that, the journey reveals other things to you. And, you know, one of the concerns that I had was that this individual, Mr. Jackson, who had a criminal record, was how he was sentenced in the past. Right, because there is a strong attraction in criminal justice that when someone has a criminal record to essentially use what we call the ladder principle, which is for each subsequent offense to impose a more onerous sentence because essentially they've been through the system and the court has already assigned a certain quantum to certain categories of offending behavior. Well, when we pulled the transcripts from the previous sentencing of Mr. Jackson in Nova Scotia, they were stunning in the way that the courts had very limited information about him. In a number of cases, they didn't even have a pre-sentence report, like none whatsoever. And they were assessing his background. And in other cases, they had a pre-sentence report that was, you know, essentially a few pages of information. And what it didn't document is that he grew up in a household where he struggled with his identity. He experienced significant trauma as a result of poverty, racism, and his mother had a significant mental health problem and an addiction issue. And that was the environment in which he grew up in. And none of the sentencing judges had had access to that information before. They didn't see how the forces of these intersections impacted his life and why he was engaged in you know, certain behavior. So that obviously set off the light bulb for us here that we need to bring this to Ontario. We need to figure out a way to do that. And so in the case of Morris, I worked with my colleague Gail Smith, and we sought out and we got the expertise of two professors who then connected us with a third professor. The first two were Dr. Carl James and Dr. Owasu Bempa, who were going to provide a contemporary report about anti-Black racism in Ontario for the court. And they linked us with now Professor Kamisha Siblis, who was a clinical social worker and was a PhD candidate, to write the first enhanced pre-sentence report that was specific to a person from Ontario. And that experience, again, revealed that how dangerous it is to sentence somebody, particularly for offenses that are routinely before the courts, like drug offenses or gun possession, that are from the Black community. And that is because, there's almost an irresistible temptation by the courts to rely on what we call ranges of sentence, which is essentially pigeonhole somebody into, well, you get 3 to 4 years if you do offense X. And then tell us a little bit about your background and we'll see how we can maybe make some adjustment to that. And to me, that was completely unsatisfactory, right? Because what it does is it feeds into the stereotype that this is just another Black young man from a marginalized neighborhood carrying a gun who poses a threat to society and particular people of privilege, when in fact, Mr. Morris was none of that. And it was only through the clinical assessment of Mr. Morris that we realized that he was a victim of racism since childhood. He was a victim of violence on multiple occasions. And as a result, he had a mental health issue, PTSD and paranoia, and he was concerned for his safety constantly. He had been stabbed in the relative recent history, and he carried the firearm for protection. And when he was arrested by the police, he was not out threatening anybody or brandishing it or using it to advance another criminal enterprise. He was stopped by the police, who thought wrongly that he was involved in some other offense they were investigating that night. And he fled because they chased him down with his vehicle, ran over his foot, and then he discarded the gun that was in his jacket and was arrested on that basis. And so that story would not have been told to the court in terms of understanding where he came from, the difficulties that he experienced, and so on, to the conventional pre-sentence report. And how do I know that? Because there was a conventional pre-sentence report ordered in the case. And it was, if you exclude the cover page, it was about 2.5 pages. And that was the basis upon which he was going to be sentenced. And I have no doubt in my mind that he would have gotten what the Crown was seeking, which was 4 to 4.5 years, had somebody not pressed pause and said, hold on a second, we don't know anything about this individual, right? Who stands before you in his early 20s with no criminal record. There's something wrong about this. And so anyway, that's a long way. I hope I didn't take too much time of telling you sort of the inspiration for the Sentencing and Parole Project and why we feel that this work is important going forward.
Thank you. You made me think of a number of things, and I'm hoping that people have questions. That racism is a public health crisis, and it is central to determining the social determinants of health for the individuals we work with. That the Black community often hasn't had access to therapeutic jurisprudent courts. And some of the work that we did with the HSJCC a number of years ago, where we conferred with a number of agencies and organizations, was that often Black clients didn't even know there were options such as drug court or mental health court. They just weren't even aware that that was a possibility, particularly drug court. And that the ministry for which I work, Solicitor General, was criticized in the past for a decline in the number of individuals released on parole, in particular Black and racialized clients not being offered the opportunity or even advised that they could apply for parole. In fact, many clients said they didn't even know that that was an option. So simply just not knowing how to navigate the system and not having someone help them with that. So having said all of that, and also keeping in mind GLADU as sort of an inspiration for this as well. As we know, GLADU, the GLADU ruling was about, was it 23 years ago now. What we've discovered is that despite the fact that GLADU exists, which is great, and GLADU reports are incredibly comprehensive and fulsome in a way that the pre-sentence reports I write are not, there have been criticisms that the GLADU system has failed in many ways because we still have a disproportionately large number of Indigenous folks in custody. So I guess my question to you, that's a long rambling way of putting it, is how do you see, what changes do you see that will make this different? I mean, how could this be different?
That's a great question. I think that the justice system should be ashamed for the failure of applying GLADU in a more earnest manner. the incredible work of Aboriginal legal services in terms of providing reports to the justice system, to judges, so that they can better understand people of Aboriginal and Indigenous backgrounds is very important. But there have been structural issues that have stood in the way of that. In particular, criminal code amendments that not only imposed more mandatory minimums, but took away the eligibility for conditional sentences and alternatives to incarceration, which were, for one moment in time, provided a real glimmer of hope, particularly in the late 1990s, that GLADU would be applied in the coming decades in a way that would be able to have some impact on the over-incarceration problem. But I think it also speaks to the bigger issue of what we see reflected here as well, that we are also challenged to overcome, and that is the failure of the justice system to truly understand the impact of the trauma, and to be able to look for alternative ways to deal with that problem. So even when jail must be imposed, ensuring that the institutions have culturally competent programs, that they have a stronger pathway, as you indicated, to parole, so that people are not left languishing in custody and feel disillusioned and come out, sometimes, if not often, in a worse situation than they were before, and thereby setting people up for failure. So I think that, there's a little bit of hope on the horizon that, there's an effort right now to reduce the number of mandatory minimums and to increase the eligibility of conditional sentences. That has been done on the backs of lawyers who have challenged the constitutionality of many of the mandatory minimums, and they've done admirable work there. But there's also been, I think, an awakening, obviously, in the last few years of racial injustice. And, there are people in government advocating openly now about this, people in the Senate, Kim Pate, amongst others, saying that, look, we cannot tolerate this, and continuing to shine a spotlight on this to ensure that there are fundamental changes so that this does not continue. I can tell you that since the Court of Appeals ruling in Morris, which was interesting because they granted the Crown appeal, but at the same time gave explicit recognition to the fact that a conditional sentence should be strongly considered by courts. And so they only modestly increased the sentence, which was really symbolic because the Crown agreed that Mr. Morris, even if the sentence was increased from a legal principle standpoint, was not going to be reincarcerated. We have seen judges to varying degrees, but mostly positive, embrace the opportunity to receive this information now and to apply it, in my view, in a more purposeful way. And I hope that that assists across the board in terms of reinvigorating the analysis in the GLADU context, because they're distinct, but there is obviously some complementary aspects, while also continuing to earnestly evaluate the anti-Black racism context. I can't emphasize this enough that, I'm very fortunate to have this conversation with all of you, and I think that it's important that we continue to have these conversations, because you cannot learn this through one session. Plenary sessions or training that has an hour segment with respect to anti-Black racism is wholly inadequate in a system that is so fraught with issues of structural and systemic discrimination. And so we have to continue to have those conversations and try to determine ways to address this. The reports are only one facet of that, right? The enhanced pre-sentence reports, or the IRCAs, they are an important piece at the sentencing stage. But I think that everybody has a responsibility and a role to play. Lawyers as advocates, people that work in the probation and parole system, recognizing that these are important issues. I was thinking about this before we had the conversation today about, my experience with assisting people and clients over the years, that ultimately go on probation. I mean, it would probably be wiser if the probation officer had access to an enhanced pre-sentence report or an IRCA before they started administering and providing oversight with respect to conditions and compliance. If the goal is really to assist somebody so that they do not reoffend and that they rehabilitate and they follow the conditions, you do need to have a good understanding of where the individual has come from and what they have struggled with and what has brought them to this point. And if they're not comfortable speaking with you as a probation or parole officer because they don't trust the system, or the trauma is such that it's not easily communicated, then that creates a deficit right there in terms of the ability to work in a manner that is collaborative and complementary if the goal is shared, which is that of rehabilitation.
Thank you. The chat has filled up rapidly with questions, so I'm just going to read some. I'm just going to read them out. The first one is from WOH. It looks like a defense counsel. Impactful opening dialogue. Thank you for that, Faisal. In your years of work, have you noticed a resistance to consider understanding the deeper history and factors which you describe?
Thank you for the question. Yes, absolutely. It has been an arduous journey that many people have done before me and broken ground. And what I tried to do was just sort of make my own contribution. And what we all shared was how difficult it was to even have this conversation, how judges were unwilling to listen to it, how Crown attorneys would, be unwelcoming. It might be too kind if you wanted to raise an issue with respect to someone's racial mistreatment. But I have seen, particularly in the last 12 months, a change there. And part of that is because of some of the leaders in the Crown Attorney's Office, who they themselves, I think, unbeknownst to me, were trying to educate their peers over years and trying to sort of, get this understanding out there. They're now got a more receptive audience, and they're able to do that internally. And then, obviously we are doing our part to educate the court and the system as much as possible. And so it's certainly in a better place than it was before. But a lot of people have been discouraged over the years of making these arguments and putting this information before the court. And thankfully, I think we're at a bit of a turning point. There's still a ton to do, and that's why I put some cautious optimism around that. But I appreciate the question, because yes, there is a history here of considerable resistance by the courts to receive this information.
Thank you. And actually, we have a comment here from a federal parole officer, Ginny Hughes. Great to have you on board, Ginny. She says, I'm a federal parole officer and I did the release planning for Jackson. I used the enhanced report you were discussing to make my recommendations. It was so helpful to aid in my understanding of this offender. Good, that's good to know.
Well, yeah, you know what, that's unexpected, and it's very nice to hear. So thank you for sharing that. That gives me motivation.
And we have from Sue McLennan, how do people get connected with your program? Will there be court workers? There used to be an African Canadian court workers. Are there still that you're aware of?
Currently there are not, which is sad, because that was a great program that existed. It was a very important resource in the courthouses where it existed. But we do have a roster of clinical social workers that have expertise in the area that are assisting in preparing the reports. We would like to expand over time to deal with some of these other avenues, but for those of you that have the ability to communicate these preferences within the system, I think that you've touched on an important point, which is we do need to have that type of resource in the courthouses again.
So we have another question here from a probation parole officer, Angela Lark. How do individuals get access to having one of these reports? I work for Toronto Anti-Guns and Gangs Probation and Parole and have had one client have an enhanced report done. I am curious as to the process. I was only made aware my client was having this report done during conversation with his mother.
Okay, another great question. So the way that it currently works in terms of being able to access the report is that the defense lawyer will request the report if the client is assisted by Legal Aid Ontario. And Legal Aid Ontario has been extremely engaged and strong in their support of advancing this issue and finding ways to support people who need reports so that they can get better outcomes. So the lawyer is the first point of access. However, we recognize that not everybody will be on a legal aid certificate. So there are ongoing discussions, which I think are going to ultimately mean that the court can order the report for people who do not fall within the basket of being someone who's covered by legal aid. And that order will come to the Sentencing and Parole Project in a similar manner in which the request by defense counsel does, so that there are not people who are sort of left outside of access.
Okay, thank you. And we have a question from the youth justice sector, Kristen Odd. I'm interested to hear about any involvement you have with youth justice. From what I understand, you aren't writing reports for youth.
We are writing reports for youth. You know, the experiences that we have doing that have been on the most serious cases where there's an issue as to whether an adult sentence will be imposed. And so you can imagine what those cases are, and we have done a number of reports in that context. To your point, however, which I think what you're getting at is sort of, well, I'll call it the more routine cases that are before the youth courts, you know, where we know in a broader sense that custody is less frequently imposed and alternatives to custody by statute must be explored vigorously. The reports are not typically ordered for that scenario. I still recommend to everybody, whether you're a lawyer or a Crown attorney or a probation officer, if you're dealing with someone that's Black and marginalized by poverty and these intersectional forces that I spoke about, that it be canvassed, because I do think requests can be made. And in those situations, we would like to assist as well, because we don't want this to be a situation where the reports are only given to people who are facing the prospect of multiple years in jail. We think it's just as important for people who are straddling the line between an outcome of diversion versus having a criminal record. But that's more of a long-term goal.
Thank you. This next question is from a probation and parole officer in our ministry as well. I have in the process of preparing a report for an individual whose lawyer chose to go with the standard PSR as the family could not afford the EPSR, the enhanced PSR. Do clients have to pay for this?
Yes, thank you for that question. So as I indicated, look, most of the people that are going to get the reports are going to come through the legal aid system, and then there will be other situations where if they're self-represented or they're in a position where they're not on a legal aid certificate, we are looking at solutions so that they can access the reports as well by way of the court ordering the report. And we've had some instances where that has happened, and we've been working diligently to ensure that the people that fit the criteria that our friend here in the question has put forward will be covered in the very near future.
And if I could just sort of jump on that, I did a pre-sentence report a few months ago, or several months ago, where the client indicated to me that an EPSR had been ordered on him as well. It was the first time I had ever talked about racial profiling in a pre-sentence report. So at the end of my career, I'm finally doing it. And there was quite a wait because of the backlog. I guess that's one of the concerns. If you have a client who's on remand and they're on remand longer because you're waiting for this enhanced PSR, it's kind of a double-edged sword. Yeah, no, look, all the questions have been great so far. So I'm glad you're giving me an opportunity to address this. So when we first started, you know, it is a primary objective of mine as someone who has experience in the justice system to provide reports in a timely manner, because I understand that the system
needs to be able to deal with cases in a responsible way. That being said, I think there needs to be some patience, in particular, given what I described at the outset, which is the history of and the contemporary circumstances of anti-Black racism in the justice system. There needs to be some patience in terms of an organization like this building its capacity to respond to the extraordinary demand that has come about in the last 6 months. And what that speaks to is the fact that there is a grave overrepresentation problem, that these reports are, when they're being used, are being considered to be quite valuable and helpful. And so the backlog, we are addressing that, and I'm fairly optimistic, by year's end that there will not be a backlog continuing, but it's sort of a confluence of factors. But that being said, when I think about whether someone's on bail, obviously it's easier to remand them, but if someone's facing the prospect of multiple years in jail, they shouldn't be rushed through the system because it's going to take a few more months to get them a report that's going to assist them here and at the parole stage. Mm-hmm. Because the reality is that if they're sentenced without that, the risk is quite high that it's going to be quite detrimental to them in the short term and long term. So, but I'm sympathetic to that, and it's very important to me as well that we address that. So it's an area that we're working on.
So the next question is from Althea Parkinson, who is a longtime CODA mental health worker who works with the Toronto South Detention Centre. And she is asking, what could I do as a frontline worker advocate for any client's factual demographics? Advocate for any client's factual demographics about any of the clients. For example, ABI, so acquired brain injury, and with all the other complex concerns impacting factors. So I guess wanting to advocate for clients with complex needs and sort of like who to go to, how to reach out.
I'm learning as we go through this, so this is fabulous. I would ask that, someone in a position like that reach out to us and provide information, particularly when they become aware that an EPSR is being worked on for someone, so that information is shared with the social worker and it can be integrated into the report. Something that is of high importance to me, and it should be to all of us, I think, is that the conditions in which people are being housed in pretrial custody and the different vulnerabilities that they have, those are also pieces of information that are not adequately before the court. And if there are people that are fulfilling those roles in the mental health side within the institutions, then that information should be shared with the court.
It would be nice if that was done on a regular basis, but unfortunately it's not. A comment from Ginny Hughes, our resident federal parole officer. She also advised us that Black offender social histories, BOSH, are now policy in the federal correctional system. At the point of intake, we are required to gather social histories and consider them in all of our decision making. Wow, it's good to know.
That's very good to know. And encourage her to reach out to us, because I'd like to hear more about that and see if we can assist in those efforts.
Sure. So another question from Jamie LeBlanc. How do we refer folks to this program to have one of these reports done? Are there any exclusionary criteria?
So that's a more complicated question. I don't know if that's coming from a parole probation side or from some other segment but the way that it typically works is these are done in the court process. We also have, and I should make this very clear, we have clients who are in the incarceral setting. They are in institutions that reach out to us to have the reports prepared for parole. And we have done numerous of those reports because they, based on the timing in which they were sentenced, they didn't even know that this existed, or we didn't exist at the time. And they're now at a point where they're closing in on a parole hearing and they want to ensure that the parole board has the best available information. So the way to do that is to reach out to us at info@sentencingproject.ca. I can probably type that into the chat group, that email, and ask us for more information, and we'll provide guidance on how to do that. So why don't I do that right now?
Okay, thank you. Thank you. So we have a comment from Michael Hamilton and a question. I completely agree that the justice system and social work system has failed inappropriately and equally serving racialized communities, but I've also seen youth involved with homelessness, addiction, and mental health from lower middle class and poor communities from all backgrounds, railroaded, no to little info, is known about the defendant and not supported as well as they should be. Do you think that this may also have a lot to do with an ineffective and crumbling justice system?
I mean, there are a lot of gaps to the point made in that question. There are a lot of gaps, and I think that, you know, if I could support probation and parole officers in that regard, I mean, our focus is to address something very specific, which is anti-Black racism, and we're going to hopefully expand to deal with other racialized communities because we see that there's a lack of understanding depending on sort of the local conditions. But in terms of saying that, you know, there are people of all different backgrounds that are marginalized for different reasons, whether it's poverty, mental health, addiction, and so on, I agree. That is what, unfortunately, is what you see the most of in the criminal justice system. And they also need to have access to better information put before the courts. And so if I can encourage probation and parole officers to essentially spend more time trying to assist people to access resources and information in that way, then hopefully I can, you know, at least make that suggestion. But, you know, I'm also a believer that we need to take this important step first because we have, you know, a very specific over-incarceration problem. And, you know, to be frank, there's a lot of stereotypes and embedded racism within the system when it approaches the understanding of Black people.
Thank you. A question from probation parole officer. For my clarification, Monica Enders, for my clarification, is the Sentencing and Parole Project preparing the enhanced, in brackets, Morris PSRs? Are community PPOs going to receive more education on writing these reports? Can we see an example of an EPSR?
Okay, so there's a few different parts to that question.
Yeah.
So yes, the SBP is preparing the enhanced pre-sentence reports. In terms of probation and parole officers, I'm respectful of the work that you know, probation and parole officers do and the important function that they serve in the justice system. But I also think that we have to be realistic about the fact that the issues that I'm speaking about today are better suited for people that have the clinical training and understanding of those intersectional experiences to be able to produce those in a report. Now, that being said, as one of the questions touched upon, which is there will be situations where the only report that's going to be tendered is the conventional pre-sentence report, or the, you know, whatever report is prepared by a parole officer, that turning their mind to these issues is a good thing. I do think it's important that they do turn their mind to these issues, but they should realize that, you know, it's very difficult for someone to open up about those types of experiences to someone that has an enforcement power over them. Mm. It's just inherently difficult to speak about it, period, to anybody. If you you know, think about the trauma that anybody's experienced in their life, you know, it's difficult for them to talk about that with their best friend, right? So to expect them to open up about that with somebody that's in that specific role is very difficult. But that being said, I do support turning the mind to it, and if it's going to be the only report that's being put forward, you know, if you can develop a relationship with somebody that'll at least give you some insight into that part of their experience, then yes.
Is it possible to see an example of an EPSR? Are there any that are publicly available?
We don't publish them because they are highly private information about people, and, you know, there's respect for the process in the sense that, yes, when they're submitted to the court, they are part of the court record, right? So if there was an individualized request for the purposes of training, then we may be able to facilitate that.
Thank you. A comment here from Louise Leonardi. Great presentation. Canadian Families in Corrections Network works with families affected by incarceration across Canada. Research shows that strengthening supportive relationships are a factor to preventing reoffending. What can we do specifically to help the Black population in custody and their families? And she's also put a link to her organization there. So what can that organization do to specifically help the Black population in custody and their families?
That's great. Yeah, no, please send us an email and we'll follow up with you. But I think in terms of answering the broader question for our discussion today, it's very important that a concerted effort be made to provide culturally competent programs to people who have suffered the type of disadvantages that I've spoken about. And there are programs that exist that provide therapy, counseling, employment skills, education services, mental health supports that are specific to the Black community. And I think that needs to be considered consistently when administering the conditions and trying to develop the plan for individuals. Because what we see through the correctional investigator report, which has looked at, what are the programs available in the federal system, there have been numerous reports that the programs are not culturally competent, that they do not speak to the needs of people that experience those specific disadvantages, and as a result, they're less effective.
Thank you. Question from Amy Zambuto from the Youth Ministry. Is the enhanced PSR ordered instead of regular PSRs, or will both be completed and submitted to court?
So I think it's available to a judge to order both. I think realistically, as time goes on, for efficiency purposes, a judge is likely to choose an enhanced pre-sentence report when the individual is from the Black community. But we have seen cases where, a pre-sentence report has been ordered, it's been received, and then it's been viewed to essentially not have enough information in it. We've had situations where a probation officer was asked to turn their mind to some of these topics and see if they could integrate it into their report. And I can say that I was impressed that the probation officer actually wrote back to the judge and said, I'm not equipped to do that. So that there was a reflection on their own skill set. And again, these are all sort of before the SBP was up and rolling. I think now that we're here, you're going to see more reports being requested on that basis. It's about getting the word out and the understanding in order to ensure that judges understand that we can prepare the report and assist the court.
Thank you. I'm trying to sort of collapse some of that. We have so many comments and questions in the chat. One of the Michelle Farmer has a couple of concerns about the youth system. She said she feels there's no support through the courts for frequent offenders who are youth. It took her son almost a year for his PSR and his mental health evaluations, and she was concerned that youth are allowed to be released to anyone and not just into programs. I don't know if you can comment on that based on your experience.
So if I'm talking more in my role as a defense lawyer, I know what she's talking about and the frustration that some parents have with respect to trying to find the right programs to assist their son or daughter. The difficulty is the justice system is sort of the place of last resort for that. It's not a suitable place to sort of rely on in order to get access to the right programs and support systems and so on. And so unfortunately, that's why that experience has existed, not just for the person who posed that question, but for many people. What I would suggest in that situation is again, it's conditional on the cooperation of the young person as well, is to try to find the resources that I was referring to earlier, which are there, that are culturally competent and there to assist. So if you have any questions, you can reach out to us and we can try to refer you to some of those programs.
Okay, thank you. they're coming in so fast, we're not going to get through them all, but I would also, one of the probation officers, my colleagues, Karen Summers, noted the marginalization of other client populations as well, and wondered if the same sort of process could be extended to non-Black clients in terms of a specialized enhanced pre-sentence report. Has there ever been any discussion about that?
There has been discussion about that, and there is support for that by the federal government. What they, I think, intend to do is to see that happen within the next few years. And as I said, it's based on the local conditions, because we know, for instance, in Nova Scotia, Ontario, Quebec, there is an overrepresentation in particular with respect to the Black community in the justice system. But if you were to go out into Alberta or BC, for instance, you would see other segments of diverse communities overrepresented. So on Ontario, obviously, we have people of all different backgrounds. And so, as I indicated before, that is part of the long-term goal, is to be able to do that.
Okay, and thank you. Scrolling through. While waiting, so this is from Tasma Miller, our probation parole officer. While waiting for funding or for reports to be paid for, what role can probation officers play in including such information that you referred to in a traditional PSR?
So I think if you're talking about a scenario where a judge has ordered a conventional pre-sentence report, or there's one that exists already, and we're going to look at that and see how it assists and what gaps in information there are and so on. I think probation and parole officers have to be honest about their own skill set and their ability to be able to understand this information, so that they can accurately reflect it in a report. And if they can't, then they should just refer it to us. And they should be open and candid with the court that this is beyond their purview, but they think that the court would benefit from having access to this information. To me, probation officers are an extension of the Attorney General's operations or Solgen's operations, which is there to support the court with truth and accuracy, right? And so if you're not in a position to do that, then you should just acknowledge that. Now, if you are in a position to do that, and we know that the systems are becoming more diverse, that the training is getting better, and you feel that you're able to do that, again, with the caveat, people in those situations are not generally going to trust that they can be open with their parole or probation officer. But if you're able to bridge that issue, then I think what needs to be looked at, you have to understand that our reports take 3 to 4 months to write, because they involve multiple interviews with the individual, with their family members, with people in the community. So it's not just about asking someone, have you experienced racism and how did that make you feel? That to me is scratching the surface, right? And so if those questions are going to be asked, it's I think the structural problem is that when a conventional pre-sentence report is, the court wants it back in between 30 to 90 days, depending on the person's in or out of custody, right? It doesn't allow a lot of time for that type of relationship to build, to be able to get access to that information. So these limitations, I think, need to be acknowledged. But going back to, if someone feels that they have the suitable skill set to do that, then they're going to have to really be willing to explore this in depth in terms of the person's background and their trajectory, their family history, their personal circumstances from childhood all the way through to when they become before the court.
Thank you. And I just want to, sorry, just trying to find the next question. So I realize we're coming to the end. One of the questions was about sorry, bear with me for a sec. Michael Tennant from the Youth Ministry. How concerned are you with the rise of the denial of systemic racism in some sectors, for example, in the US, and the resistance to critical race theory and the right-leaning resistance to being woke, and getting pushback here on the need for enhanced PSRs? Quite relevant in light of what happened in Buffalo the other day.
Yeah, I'd like to think that, It's a question that makes me pause and reflect, because I said to you earlier, I've lived the experience of where the resistance was visceral in terms of trying to make these arguments. And it's only been very recently, in part because of the litigation, in part because of the, you know, merciless killing of George Floyd in front of everybody's eyes, and the activism that inspired. Although knowing that that's existed for way too long before that. As I said to you, we're kind of at a turning point. So my optimism is somewhat cautious that there's going to be a greater willingness to receive this information. But every time you take a step forward, it feels like there's going to be forces that want to push you back 2 steps. And so, you know, I'm not naive to that. That as we make this progress, there are going to be people in all different facets of the system that are going to be looking for a way to essentially say, well, hold on a second, which is the fear that you identified with GLADU, which I think was also part of the framework there, which is the oppressive forces that, you know, people were essentially picking what they wanted from it and then still essentially imposing the same types of sentences that they were before. So I don't have a great answer to that other than to say, yes, I hear you, and I am cautious about that. But, you know, I think for this moment right now, we are at a time where the courts are being told that this information is important, that you should get it when you can get it, and you should make an earnest effort to apply it. And all I can do is try to assist in the education process so that people do that.
Thank you. And we have 2 minutes left. I don't think we'll get to all of the comments or questions, but I'm thinking if there's something really that we haven't addressed, if I could email you and you could share an answer to that after the webinar, I would really appreciate that. If there's really enthusiastic uptake to hear from you. One last question. Does this change how a clinical assessment is done in the institutions for parole hearings that you're aware of?
I would like to see some transformation here. I know that, you know, in the relevant statutory body, for instance, that when it comes to the Indigenous population, and this may be more theory than reality, but at least it's in the statute, that systemic disadvantage is not to be used improperly and essentially converted into aggravating factors or risk factors that are used to deny people release and put them on more onerous conditions. There's no similar language to my understanding for people from the Black community, and I would like to see that happen. And I would also like to see this type of information carried through. And so we do make that recommendation to judges that they put it on the warrant or remand and that it carry all the way through so that, you know, the parole officer can have access to this information. You know, to me, it gives them a head start, and that will also help in the risk assessment. You know, I can tell you as well that psychologists and psychiatrists have reached out to us who are asked to do the clinical assessments from youth to adults and have told us that they actually benefit from having this information because they themselves struggle to access this during their interviews with the clients and so on.
Thank you. Thank you so much. I will look at the rest of the messages, and if I can sort of distill it, I will send it to you. And then if you could answer and we could share that information. If I could just remind people to please fill out the evaluations as well. And I just really want to thank Faisal for taking an hour of his very busy day to share. Thank you for sharing your expertise and your passion for this work. It is really inspirational, and I hope that it affects significant systems change. We can certainly hope. And I wish you a lot of luck with the work that you're doing going forward. I think you have a lot of fans now.
Thank you so much for having me. It's been a pleasure to be here, and I appreciated the opportunity. The questions were excellent, and you know, please feel free to reach out to us at the project if you have any questions. We want to, you know, support people. I know that the, you know, people who are working in the different parts of the system are working hard, and we want to make sure that the best information is put before the courts. Thank you.
Thank you very much. And thanks everybody for attending. Domenica?
Yeah, I just wanted to read a comment that Sue McLennan wrote in the chat that she wrote, unfortunately, the GLADU program isn't funded or regarded equally across the country. the system has failed rather than the GLAD-2 program has failed. I just wanted to note that.
Thank you. Thank you for noting that, Domenica. Thank you. Thank you, everybody, for attending. Please take care, stay safe, and we will keep working. And thank you, Domenica, for all of your help. And thanks, Faisal. Take care.
Thank you. Thank you.
Bye, everybody.
Bye.